organ. The applicant alleged that the filing of the matter before the National Judiciary was followed by numerous death threats against him and other members of the legitimate board as a continuation of previous harassments relating to their human rights work. As a result, the applicant claims that, fearing for his own safety and the safety of his family, he fled to the country on the 3rd March 2014, yet the death threats continued to the date of filing the application. The applicant assessed that on 1st November 2014, other members of the legitimate board were arbitrarily arrested while they were planning for an extraordinary session scheduled for 23rd November 2014 to review the status of Librador. Although they were subsequently released at different times, pursuant to an order of the High Court of Kigali, the mayor of Nyarugenge district issued a communique prohibiting the extraordinary session from being held. The applicant states that even though the organization remains under the name of Librador, it no longer operates autonomously, as the unlawful elected leadership of Librador has consoled the organization human rights work that is deemed to be too critical of the respondent state's lack of observance of its human rights obligations. Alleged violations. The applicant alleges the violation of his first right to freedom from discrimination under Article 2, right to equal and equality and equal protection of the law under Article 3, right to a fair trial, right to receive information and freedom to express his opinions under Article 9, right to freedom of association and assembly under Article 10, and right to work, and by failing to prevent and sanction private violations of human rights through independence and impartial courts. The respondent state has violated Article 1, 2, 3, 7, 9, 10, 11, 15, and 26 of the Charter. Prayers of the parties. The applicant prays the court to order the respondent state, 1, to publicly recognize and accept responsibility for the violation perpetrated against the applicant and the legitimate board of Librador, giving effect to the decision of the court and issue a public apology. Second, nullify the respective decisions of the High Court and the Rwanda Governance Board denying rightful relief to the applicant and the legitimate board. Third, immediately and fully restore the applicant and the legitimate board to their rightful position of leadership in Librador prior to their unlawful ousting. Fourth, immediately initiate effective and impartial investigation into the threats and acts of intimidation against the applicant and the legitimate board in order to ensure that those responsible are brought to the justice. Fifth, issue reparations, including prompt and adequate compensation to the applicant, the legitimate board and their representatives, including material damage, psychological and social service material damage, loss of opportunities, and moral damage, among others, the court should see fit. Six, publicly condemn threats and other forms of intimidation against independent human rights defenders and recognize the importance of their action in favor of the promotion and protection of human rights and fundamental freedoms. 7, reform the domestic legal framework regulating non-government organizations in order to remove impermissible restrictions on their rights to freedom of association, assembly, and expression. 8, to take immediate and all necessary steps to strengthening independence of the judiciary. 9, initiate a broader legal reform process with the purpose of creating an enabling environment for civil society in the country. And 10th, take all other necessary steps to redress the alleged human rights violation. The applicant further praised the court to order the respondent state to first reinstate the lawfully legitimate board, second, guarantee his safe return from exile, third, investigate ongoing threats and intimidation against him and other members of the legitimate board of Liprodor, fourth, nullify to the respective decisions of the High Court and of the Rwandan governance board that denies his rightful relief to him and the legitimate board of Liprodor. Fifth, pay monetary compensation in the amount of 1,082,515 euros for the material prejudice to himself and his family members relating to costs associated with freeing Rwanda, loss earning, legal fee, travel expenses, as well as for material loss incurred by Liprodor. And 6, pay 55,000 euros for moral prejudice suffered by the applicant as a result of psychological distress and anguish, reputational harm, disruption of his social and occupational life. 7, pay 55,000 euro for moral pay 55,000 euro for moral prejudice suffered by his wife, as well as 75,000 euro in compensation for the moral prejudice that his 3 children have suffered. 8, pay 200,000 euro to the other members of the Liprodor, rightful board members and staff. 9, pay compensation to Liprodor for the moral damages inflicted through the illegal takeover of its board and the ensuring disparagement of its human rights work. 10, publication of the court's judgment and its summary within 6 months, effective from the date of the judgment in English or French. And 11, make a public apology and official acknowledgement of wrongdoings. 12, issue official declaration restoring the dignity and reputation of Liprodor, the applicant and other legitimate board members, and acknowledge the role of human rights defenders. 13, include an accurate account of this case and information about the importance of civil society organization in educational materials throughout Rwanda society. And 14, guarantee non-repetition of condemning threats and intimidation against independent human rights defenders. And 15, undertake legal reforms of amending laws governing the freedom of association, assembly, and expression. And 16, improve judicial independence and ensure all proceedings thereof abide by the due process standards. In the operative part, the courts considered the submissions and all the submission by the parties and made an analysis. At the end, they came to the conclusion for those reasons, the court anonymously on jurisdiction declares that it has jurisdiction according to the governing laws and the facts of the case and submission by the parties. And by majority of 8 for and 2 against, Justice Rafa Ben Shaw and Justice Ben Kioko dissenting, on admissibility as according to the governing laws and the facts of the case, including the submissions by the party, the court came to the conclusion that and declares the application is inadmissible. On costs, the court orders each party to bear its own costs. This decision of the court is signed by Iman Daoud Aboud, President, Blaise Chikaya, Vice President, Ben Kioko, Rafa Beneshu, Susan Menge, Jujilani Chizumila Chafika Ben Saula, Stella Anuka, Dumisa Zebeza Madibo Sako, and the registrar. In accordance with Article 28 sub 7 of the protocol and Rule 70 of the rules, the dissenting opinions of Justice Rafa Benashir and Justice Ben Kioko are appended to this ruling. This is done at Dar es Salaam this second day of December in the year 2021 in English and French, both the French and English texts being equal authoritative. This is the decision of the court.
Thank you, Madam President.